So over the last 5 years or so, we've seen this at trial and when we file cases, is that there's always going to be, in the state of Missouri anyways, an allegation of comparative negligence on the behalf of the plaintiff, or the plaintiff did something that contributed to their injuries, a certain percentage. Now, Missouri is a pure comparative state, so if the plaintiff was even 99% at fault, they can still recover that 1% of their damages. Now, what we see, though, is that very often the insurance companies are asserting comparative fault claims against plaintiffs when there just isn't substantial evidence to support it. And that's important because the case law in Missouri says there must be substantial evidence to support a claim of comparative fault. Most people don't realize that. However, when you get these cases filed, when we file them, and we get the defenses back that are being asserted against the plaintiff, that the plaintiff was comparatively at fault, we really have to work hard to narrow those down, strike those defenses, or make the defendant make them more specific. Because most of the time, the defendants are just shotgunning these out. They don't really know, they're just putting these answers out there, and they don't have facts to support those comparative fault allegations. So if you're watching this video and they say, well, I'm comparatively or contributorily negligent, or they call some of them called comp neg, depending on which insurance company you're dealing with, what they're really saying is, hey, you injured party, you're partly at fault for this. And there may be no evidence to support that. But what the insurance company is going to do is take an arbitrary percentage that they make up and deduct that from your damages. So if you had $100,000 worth of damages and they just come up and say, well, this is an intersection crash and we believe you should have seen the defendant in time to react, or you failed to keep a careful lookout, we're going to deduct 30% from your damages. That's what they're talking about with comparative fault. And this is pre-suit. Any insurance company can do this. It's totally up to them. It is 100% arbitrary. And so that's why it's important to get to an attorney. They can get this case going to trial, and they can really force the defendant to lay out the facts that support their claims of comparative negligence.